Hello, everyone, and welcome to ECIPE's Global Economy podcast. My name is Fredrik Eriksson, and today I am joined by my colleague, Oscar Guinea, who is a senior economist and director at ECIPE as well. Hello, Oscar.
Hi, hello.
How are you?
I'm all right. Yourself?
Oh, not too bad, not too bad. We're recording this on a Friday, so I think we're both looking forward to some well-earned rest of the weekend. Oscar, we are going to talk about the Product Liability Directive today. And before we start this conversation, let me just set this up a little bit. We have in the past been doing a lot of work related to what sort of technically can be called collective litigation, basically mass litigation, that we have a process where many more countries in Europe are almost going in an American direction when it comes to using courts to deal with sometimes injury and liability issues. But we have seen a development where courts and these procedures of collective litigation also becomes the subject for many other types of things. And it's partly been spurred by the European Union itself, because over time it has introduced a number of new regulations, like, for instance, the GDPR, or in competition policy, or in financial services regulation, that encourages people to use courts in order to have a sort of private enforcement coming on top of the public enforcement that we have in most parts of Europe in terms of how companies need to follow regulations. And if they don't, they're going to hear from government entities that they are doing something wrong. Now, to me, this has become a bit of a strange issue, especially in the past years, because on the one hand, we have a new competitiveness drive in Europe where we want to reduce the burden of regulation, where we want to reduce the complexities and the costs that come with not just an increased burden of regulation, but also with complex regulations that makes it much more difficult to innovate and to compete and to experiment and to explore for companies. But on the other hand, we have a parallel development where we have either regulations that were decided a while ago and that are now in the process of being introduced, or we have new regulations that almost go against that pursuit or that objective of trying to raise the competitiveness and innovativeness of Europe. So I think this is part of the context that I would like to start with when we talk about the Product Liability Directive, because in my view, at least, I'm curious what you think, Oscar, but in my view, this is one of the regulations that falls into that second category, which is it goes against the pursuit of trying to improve competitiveness, innovation, and economic growth in the European Union. But before going into that aspect, Oscar, why don't you sort of start to lay out for us what is the Product Liability Directive? What is changing with this new directive, and why is it such a big deal?
Thanks for the introduction, Frederick. So the EU's liability rules were designed for a world of physical goods. Think about faulty toasters or unsafe cars. But now we live in a digital economy. Our cars are driven by software, our medical devices are connected to the cloud. So what the new PLD, the Product Liability Directive, does is it's an attempt to catch up with this new reality, with this new digital economy. And the most significant change of the directive is that it has expanded the scope of products. So for the first time, the definition of a product not officially includes software, includes AI systems, algorithms, and even digital files that are exchanged between manufacturers and producers. But it does not stop there. The directive also makes it significantly easier for claimants to sue. So it introduces new rules that lower the burden of proof. For instance, if a manufacturer refuses to disclose technical information, the court can now simply presume that the product was defective. And why this is a big deal? It's a big deal because, as you have alluded in the introduction, it fundamentally changes the balance of risk, but make it easier to sue, and expanding what you can be sued for. The PLD creates a fertile ground for the kind of litigation that we have seen in the United States. So we are moving from a traditional European model of proactive safety regulation to a system that relies more on private lawsuit after the harm has occurred.
All right. So, am I understanding you correctly then? So, your point here is that the PLD is going to exacerbate that trend of private litigation or mass litigation that I was alluding to in the introduction. And if that's okay, how is the PLD exactly going to do that?
Precisely. I mean, the PLD doesn't just appear in a vacuum. It lands in a European market where the infrastructure for mass litigation it's already been built. So we are seeing, and we have been documenting in our studies, the rise in the number of litigation funders, specialized law firms, and digital platforms that are designed to bundle thousands of claims. And what the PLD does is accelerates these trends, and it does it in three ways. First, it lowers the barriers to entry for lawsuits. The new rules make it much easier and cheaper for a claimant to build a case. And for litigation funders, who are those kind of uh, companies and organizations behind some of these mass litigation suits, they it kind of it lowers the risk of their investments. The second thing that it does is that the PLD expands the pools of potential targets. By including software and AI, the directive makes virtually every technology company in Europe, big or small, a potential defendant against a lawsuit. So a single bug in an app that affects users in similar ways can now be the basic for a massive collective action. And this is important because the potential returns on investment for funders is scaled with the number of claimants they can gather. And finally, it creates a powerful new business model. The combination of lower risk and a larger market turns mass litigation into a highly attractive asset class for financial investors.
Hmm. So we expand liability rules to include software, AI, digital products. To me, that sounds like something different than having liability rule for the toaster. I think was the example that you pointed to yourself. I mean, a toaster is not exactly a complex product. It may be, I don't know. It doesn't come across as being a very complex product. But when we talk about AI and perhaps adding AI functionality to, say, medical technology or to self-driving cars, you have autonomous driving system, etc. That sounds a bit complicated. Um, so obviously, there must be some consequences for that on the economy. For instance, on innovation. I mean, if I was, um, say, a company that was going to produce, so let's say I'm producing already a product which is on the market, but now I have an opportunity to improve either the product or the use of the product or the experience of the user by adding different softwares and different AI to it. I probably would have been skeptical of doing that if I also know that it's going to expose me to a lot of new risks in the EU. I may not bring that type of innovation to Europe. Wouldn't you agree?
Absolutely. If you if you read the product liability directive, I think you can actually get is that the digital and the technology sectors are the primary target of this directive. Uh, Suing over complex technologies will become substantially easier, and the impact on innovation will be profound. So, to me, the core problem of the PLD is that it tries to regulate software and AI using the framework and the mental models of physical objects. But a software is not a toaster. A
Mm,
software is dynamic. It's constantly updating. We see that on our mobile phones. And in the case of AI, you can even argue that it's kind of constantly learning. So let's
mm,
use an example. Uh, the PLD says that a product is defective if it doesn't meet what the public considers safe, if it's not safe. But what is the expectation of safety for AI? Let's say that if a self-driving car software is updated and now makes this and becomes 10% safer, does that means that the previous version of the software was defective? Any engineer will call that progress. We make the software better, but a litigation lawyer probably will call it an admission of guilt. And this creates a chilling effect on
An
innovation,
opportunity.
a business opportunity. Yes, companies will face a choice: either they slow down the development and they focus on legal proofing, or they risk a lawsuit. And our research showed that the mere just feeling a collective action can cause a significant drop in the market value of a company. So imagine for a startup, the reputational damage of facing a mass litigation lawsuit can be a death sentence. And this, as you mentioned, this ultimately will impact the impact of PLD is that incentivize caution over creativity. It promotes incremental innovation rather than radical innovation. And this is a self-inflicting wound. And it has been said many times with regards to other EU regulations that the AI Act, the risk is that the EU becomes excellent at regulating technology, but very bad at creating it.
So it basically goes against the bigger objectives with competitiveness and innovation then that
Indeed.
at least this European Commission had set out for itself. So, but let's go back to the PLD a little bit more and on the not the technical but the sort of application of it. So this is not going to be introduced as a regulation in the EU, which is that it's introduced in the same way in all EU countries. It's going to be introduced in different ways. And I assume these differences between countries will also play into that broader concern about growing litigation, right? I mean, we have some countries in Europe where litigation is much more common in other countries. So aren't you going to get a lot of forum shopping where lawyers, the type of investors that fund collective actions, aren't they going to use especially some countries and perhaps how the PLD are introduced there in order to bring a lot of new cases?
Yes, I mean, the PLD leaves significant room for national variation. And this is likely to create a patchwork of legal systems. And you can be sure that funders and lawyers are already mapping out the most favorable countries to launch a lawsuit, kind of looking to see if there is any kind of opportunity. And our research has an index. We have created an index that measures kind of these things. We call it the Institutional Framework for Mass Litigation Index, and it looks at factors like whether a country has an opt-out or opt-in system, whether it has a weak or strong loser pays principles, at the number of litigation funders that there are in a specific country. And what we found is that there is a direct correlation. The easier it is to launch a collective action, the more cases it has. And for instance, let me give you an example. The Netherlands scores very high in our index, and it has also become a hub for mass litigation in the EU. What the PLD, what it does is amplifies this. So a law firm in Germany could file a case in a Dutch court simply because the rules there in the Netherlands make it easier to win the case. And this is not hypothetical. The Representative Action Directive is designed to allow for this kind of cross-border lawsuits and cross-border behavior. So instead of having a legal playing field, what we get is a distorted market where legal outcomes really depend on not on the merit of the case, but where the lawsuit is being filed. And this has serious consequences. I mean, a company has to be prepared to defend itself under the most litigious friendly rules available anywhere in the EU.
I mean, that's a complexity in itself. I would imagine that we have, in a way, you can say we have a common market but separate legal systems. Isn't there a risk that these sort of separate legal systems, with some countries being these hubs for litigation, that we can start to see consequences even for the single market and sort of the common economy that we try to have in Europe. To me,
Absolutely.
yeah.
Sorry.
No, go ahead.
No, I think this is an existential threat that unchecked mass litigation presents to the EU. What is the single market? The single market is built on harmonized rules. When one member state creates a highly permissive environment for lawsuits, for collective actions, it is exporting this environment to all the other member states. Now, let's imagine that we have an Irish company which is being sued in a Dutch court, where the rules are far more favorable for claimants, as I explained before. The Dutch court decision has a direct financial impact on the Irish company. And if this happens at a scale, the consequences for the single market are profound because companies in countries where public enforcement prevails and where there are strong safeguards to avoid the growth of mass litigation, like in Ireland, might become hesitant to innovate, which is connected to the previous question about the effect on innovation. And at the same time, they might think twice about selling the products and services across the border in case they are dragged into a legal battle in another member state. And this splits the single market. What's the goal of the single market? The goal of the single market is to create a level playing field where companies can compete on the quality of the goods and the services. But when a country opens the floodgates to mass litigation, the competition shifts. It's no longer about who makes the best products, but about who has the deepest pockets to withstand a legal battle. And that's not really a healthy foundation for Europe's long term prosperity.
Hmm. May I take you from one geography to another? So you've been talking about the Netherlands now. Let me take you to my native country, Sweden, which I love to talk about. The reason for why I'm bringing Sweden up is, my experience of these issues is from not just Sweden, but perhaps from Nordic politics more generally, is that they have deliberately trying to avoid that development over a long period of time. They didn't want to have courts dealing with injury and liability issues. They didn't want to have a commercialization of injury and liability cases either. They rather wanted to use alternative dispute resolutions in order to deal with it. So we have had a system on sort of a pretty fast-paced, pretty effective systems where anyone can go to what is almost like a semi-authority, and you can make a claim, and you're going to have a pretty quick decision coming from a panel of different experts that are invited in. If they found in your favor, you're most likely also going to get some injury award for a defective product, and if it also caused you some physical harm, you're going to get an award and compensation for that as well. Then above that, there is an ombudsman system, a consumer ombudsman system that can also do mass claims in courts if they believe that there are lots of customers that have been or that are rightly aggrieved because of a defective product. And that system was also trying to balance between different interests here, which is that on the one hand, you do want to have a right for consumers to bring claims, and that is a good thing. You also want to find court efficiencies or legal efficiencies. So if there are many people that have been injured by the same product, you don't want to go through a process doing sort of person by person. You can actually group them together and you do a collective process around it. But that interest, on the other hand, is balanced by the interest to avoid a lot of financialization of justice, where you're going to have investors and lawyers that are going to just use the courts in order to benefit themselves from these type of mass claims that we've been seeing in America. So here we have, that was a long-winded introduction to my interest just to ask about these things, because what is the PLD going to do to these countries? I mean, they don't want to have a system where courts are going to be sort of empowered or going to become open to to a lot of different mass claims. So how are they going to implement the PLD to maintain the integrity of the system?
Yeah, the Nordics are a really interesting example because they are global leaders in innovation. And as we have discussed, this is a very important feature of the PLD and a risk. And at the same time, they provide effective consumer protection. So I think that what you have kind of explained very well is that the difference here is how they do it. And the Nordic model is not based on litigation; it's based on public enforcement and a powerful consumer ombudsman. So, correct me if I'm wrong here, Frederick, but if you have a problem in Sweden with a product, the first thing that you do is not to hire a lawyer. You go to the National Board of Consumer Disputes, right? And then you
Yeah,
make your
exactly.
case. And that is designed to provide you with a quick, low cost, and fair consumer redress.
Yeah,
And it
I
works
don't
because
need to pay anything.
indeed our data shows that citizens in Finland, Denmark, and Sweden they rarely feel the need to go to court for these things. And there is a danger here, as you mentioned, is that the PLD could undermine the Nordic model that works really well. So the question is, because at the end of the day, the Nordic countries, I mean, all the EU countries, they need to implement the PLD. So how you do it without compromising, undermining your system? And here I have kind of three humble suggestions. The first one is that um, the three Nordic countries, they should clarify the new legal principles in a way that aligns with their own legal traditions. For instance, the new presumption of effectiveness should ensure that the burden of proof doesn't completely shift to the defendant. Second, they must preserve the central role of the ombudsman model. Litigation must remain a last resort, not a default option. And finally, they need to maintain crucial legal safeguards. For instance, the development risk defense, which protects companies from liability or from undetectable defects, that should remain to be the case.
Mm. All right. Well, that gives me some reassurance. Thank you, Oscar. Finally, I mean, you've been working on different type of aspects of not just the product liability directive, but also on the rise of collective litigation in Europe. You've been working on for the sort of papers on the EU, on the Netherlands, Germany, Ireland, the UK, Nordic countries. So if I ask you this, fast forward 10 years from now, where do you think this whole development is going? Where are we about to end up?
I think if we continue down this path, the European business landscape could look very different. And I see three major transformations. First is the rise of a litigation economy. Yes, as we have a financial service sector, we will have a fully fledged litigation industry. And this is important because business decisions will be shaped not by market opportunities, but by litigation risk. As it is the case in the United States now, the cost of liability insurance will become a major operational expense and an expense that will pass on. It will be passed on to consumers. But, and this is an important but, unlike the US, the higher liability insurance costs for European companies will be added on top of the already high regulatory costs that we have in the EU. It's not one system or the other, it's one on top of the other. The combined effect of the litigation economy and the high regulatory burden will be a significant drag on EU competitiveness. The second is that Europe will suffer from an innovation deficit. So the most dynamic and disruptive companies will be the ones most exposed to litigation. The sectors that will drive future innovation and the digital economy will be exposed to mass litigation. And investment will shift, will move from breakthrough R&D towards safer incremental improvements. And the third one is that the single market will be weaker and more fragmented. We could see the emergence of a high litigation block of countries and another block of countries with stronger safeguards to avoid abuses in mass litigation. This will create deep divisions and mistrust between member states. And for sure, cases from the high litigation block will permeate into the other block, and that will go against economic integration within the EU. So in this future, and the cost of doing business in Europe will be higher, our competitiveness will be lower, and the single market will be compromised. And this is an important point as well, the irony of all that is that the primary beneficiaries will not be consumers. The primary beneficiaries
Who will it be?
will be the financial actors who are behind the collective actions,
Oh.
who will receive the returns. It's a bleak picture, but let's not finish with such a pessimist take, right? It's Friday after all. It's not.
Well, I mean, it's always going to be a positive thing coming from bankers and lawyers. They're always going to find a way to land on their feet, right?
Let's try to avoid that.
Yeah.
This future is not inevitable, so there is time to change course, and there is a possibility we can do that. I mean, we can have an EU-wide legislation on third-party litigation funding that can set clear rules and prevent foreign shopping. We can have a transposition of the PLD across the EU in a way that avoids the reversal of the burden of proof and preserve the central role of public enforcement. And we can also learn from good cases that we have within the EU and support and promote alternative dispute resolution mechanisms to provide consumer redress rather than litigation.
So back to Sweden.
That's it.
Yeah, all right, very good. Oscar, I think we have to end our conversation there. We could have continued. Thank you very much indeed for enlightening me and others on this wonderful world of the Product Liability Directive and the rise of collective litigation in Europe. I should also say that if you are interested to read more about it, there are plenty of papers available on the website of ECIPE, and you can also browse a lot of things that we've done on the new trend of private enforcement in Europe. And as Oscar just said, a development which comes on top of an already existing burdensome and costly public enforcement in Europe. So this is not America, where private enforcement is basically the enforcement system that you have to keep companies in check. We have a different system in Europe for it, and now we're adding a new one in parallel or on top of the existing one, which is doubling the costs of it. So thank you very much, Oscar. It was lovely talking to you.
Thank you very much for having me, Frederick.